Good day. My name is Charene Nortier, and I'm with the Financial Advisory and Intermediaries Department at the FSCA. I am joined by my colleague Tshepo Mogale today, and we are going to be talking about debarments that are affected by the authority. Tshepo, thank you for joining me to discuss this very important topic.
Thank you, Charene. There are two processes of debarments, and some FSPs are often confused by the two processes available. The process under Section 14 of the FAIS Act governs the FSP to debar its representatives, and the process in terms of Section 153 of the FSR Act governs the FSCA to debar a natural person. This section repealed Section 14A of the FAIS Act as of the 1st of April 2018. The former process is initiated and run by the FSP, and the latter process by the regulator.
Thank you, Tshepo. Can you please explain what Section 153 is all about?
In terms of Section 153 of the FSR Act, the responsible authority for a financial sector law may make a debarment order in respect of a natural person if the person has, number one, contravened a financial sector law in a material way, contravened in a material way an enforceable undertaking that was accepted by the responsible authority in terms of Section 151 of the FSR Act, and attempted or conspired with, aided, abetted, induced, incited, or procured another person to contravene a financial sector law in a material way, or contravened in a material way a law of a foreign country that corresponds to a financial sector law.
It is clear that the common issue is that the contravention must be material. Can you explain how you get to know about these contraventions?
Okay, what happens is that the FSCA receives information about the wrongful conduct of a natural person. It can either be from the FSP, from the members of the public, from the Ombudsman, other regulators, the clients of the respondent, or any other source. Then what happens is that the FSCA investigates the matter, and as soon as we have completed our investigation, an ITC report will be conducted on the person's latest contact details in compliance with Section 155 of the FSR Act. We will then draft a notice of intention to debar, which will be sent to the respondent in order to afford him or her a chance to respond to the allegations.
What happens when you have drafted this notice of intention?
Okay, so what happens is that obviously the person needs to be informed or notified of the debarment. And the authority must also inform the person of the intended period of the debarment and any terms to be attached to that debarment.
So if I receive this notice of intention, how much time do I have to respond?
As soon as you receive in terms of the Act, as soon as you receive the notice, you have 30 days within which to respond to the notice.
So if I've now responded, what happens to that response?
So depending on the response or lack thereof, the matter may be closed or a final debarment order be granted.
Can we unpack this a little bit? You've already conducted an investigation before you sent the notice of intention. I now receive this notice and I respond. And depending on my response, you could actually close the case here and not take it any further.
Yes, that's correct, Charene. After considering the respondent's submission and accompanying evidence together with the information at our disposal, we then make a decision whether or not to debar or not debar a person.
Thank you.
So as soon as the debarment period has passed, the debarment automatically falls away.
What does this mean? Must I apply or can I work as a representative again?
Yes, as soon as the debarment has fallen away, a person can apply to either be a KI, FSP, or REP. However, if the person applies to be an FSP or a KI, the FSA will consider the application, and if the person applies to be a rep of an FSP, then it's the duty of an FSP to make or to do due diligence to see if the person is fit and proper to be a rep.
Can we explore the debarment order in more detail? What am I not allowed to do if I have a debarment order that is issued against me?
Okay, a debarment order prohibits the natural person for a period specified in the debarment order from: number 1, providing or being involved in the provision of specified financial products or financial services, generally or in the circumstances specified in the order. Secondly, acting as a key person of a financial institution or providing specified services to a financial institution, whether under outsourcing arrangement or otherwise. And a debarment order in respect of a natural person takes effect from the date on which it is served on the person, or if the order specifies a later date, the later date. And a natural person who is subject to a debarment order may not engage in conduct that directly or indirectly contravenes the debarment order. The responsible authority must publish the debarment order.
So, Tshepo, can I ask about this publication of the debarment order? Does this mean that a prospective employer could search on the FSCA's website to see if there is a debarment issued against me?
Yes. Any person can search for a debarment order on the FSCA's website by using the identity number, the name of the person, and surname. And the debarment order is available on our website.
Okay, that's useful to know. Thank you. Can you explain the period of debarment? How is that period of debarment determined? Because it's not the same period for every person. What do you take into account when you decide if it is a 1 year, a 5 year, or even a 10-year period?
Okay, in determining the proposed debarment period, the conduct of authority, which is the FSCA, considers the following: the seriousness of the allegations leveled against the person, the actual or potential prejudice suffered by the client, the number of allegations leveled against the person, and the negative impact which the alleged conduct has on the financial industry.
That's very interesting. It's useful to understand how the periods are determined. But can I ask, if I've now received a debarment order, is there anything I can do? Can I appeal against it?
Yes, a person aggrieved by a decision may apply to the tribunal for a reconsideration of the decision by the tribunal in terms of Section 230 of the FSR Act, I'm sorry. And the details, contact details of the tribunal are as follows: 012 741 4300, 012 741 4302, or 012 741 4303, or via an email, which is applications@fstribunal.co.za.
Thank you, Tshepo. That contact details are really useful for people. Are there any challenges that the tribunal encounter when they receive such applications?
Yes. Number one, dealing with applications with no merit. That means that some applications are lodged without no prospect of success, as there's no legal grounds. I mean, for example, if the debarment was done correctly, let's say, for example, it was for fraud or for theft or for whatever reason, then there is no prospect of success. Secondly, if the applicants don't meet the prescribed period within which to apply without just reason, the prescribed period in which to lodge an application, it's 60 days. So after 60 days, then unfortunately, maybe if the applicant can do it via condonation and give valid reasons why they didn't lodge an appeal or reconsideration within the specified time, maybe the tribunal will consider that. But I'm not talking on behalf of the tribunal. That is just my understanding. And in some instances, some debarred persons misunderstand who the decision maker is. By that I mean, if the FSP or the rep is being debarred by the FSP, then the FSCA is not the decision maker. So the reconsideration and appeals will be dealt with differently. And lastly will be failure by applicants to engage in the application in terms of the rules of the tribunal. By that I mean, there are rules of the tribunal that are prescriptive with regards to the time frame within which pleadings should be filed.
Thank you very much, Tshepo. You've really unpacked a very tricky and a very difficult topic in very clear terms, and I appreciate that. And I think that everyone who watched this webinar will also understand this a lot better. Right at the start, you mentioned that there are two different processes, and you were dealing with Section 153 of the FSR Act. We also have a webinar that has been recorded and is also available on the debarments in terms of Section 14.1 of the FAIS Act. So if there are any persons who are interested in those debarments, can I also urge you to go and watch that webinar that we've got available. And then just to remind everyone that we have engaged with the Financial Planning Institute, and we have accredited our webinar for CPD purposes. So if you would like to get some CPD recognition for having watched these webinars, after every webinar, you have to register for the attendance of the webinar, and then you will get access to an assessment. The assessment questions are always based on the discussions and the slides of the webinar. Once you've successfully completed the assessment, you are then able to download and save your CPD certificate. Please then save that CPD certificate to your own records, but also make it available to your FSP, to your employer, so that they can add it to their competence register, which they are also obliged to keep. We again want to thank you for participating. Without your participation and watching our webinars, we would not be able to continue to host them. We really appreciate your support. Tshepo, for you, for the effort that you've put in, I really thank you. Have a wonderful evening.
Thank you, Charene, and goodbye.